The Bombay High Court, in the case of Tata Motors Finance Solutions versus Naushad Khan, delivered a significant judgment. The Bombay High Court in this judgment held that financial institutions, which fall under the definition of financial institutions under the Recovery of Debts and Bankruptcy Act 1993, are not entitled to arbitrate their disputes, which relate to the determination of the amount of debt. Today, Arjun and I are going to be discussing the practical implications of this judgment. So before we move on to discussing the practical implications of this case, let me just give a brief background on the factual scenario. So in this case, the lender and the borrower had entered into a loan agreement which had a collateral as well. Now this loan agreement also had an arbitration clause. The borrower, during the period of the existence of the agreement, began defaulting on certain repayments and sold off and was attempting to sell off further securities that were given as collateral. Now, the lender in this situation filed two applications. First, for the appointment of an arbitrator, and second, to secure the assets that were given as collateral. The borrower raised an objection to this on the maintainability of the applications. So given this background, let us now understand what was held and what are the practical implications of this.
So thank you, Shruti, for this introduction. The Bombay High Court essentially delved into the scope of the two legislations, which is SARFAESI and the RDB Act. The SARFAESI Act essentially deals with the enforcement of security provided by the borrower without intervention of courts. And the RDB Act essentially provides a special forum, which is the Debt Recovery Tribunal, where a lender can initiate legal proceedings to recover the amounts due from the borrower. Now, the DRT obviously indulges in an exercise of adjudication and crystallization of the amounts which are due and payable to the lender by the borrower. And finally, there would also be an exercise of recovery which is done by the recovery officer basis the recovery certificate issued by the DRT. But under the SARFAESI, there is no scope for a lender to actually go for crystallization or adjudication of the amount payable to the lender through the DRT. The idea is to only bypass any court-driven process and directly go to the enforcement of security. And also, the definition of financial institution under SARFAESI and the RDB Act are different. They don't have an exactly overlapping scope. Keeping these distinctions in mind, the Bombay High Court said that although SARFAESI as a statutory mechanism is available to the lender to recover its amounts or to recover the dues payable to it, that does not enable the lender to go through a process of adjudication and crystallization of the debt due. The only option available to the lender under SARFAESI would be to directly go and enforce the security already available with it. And as Shruti had mentioned some time back, some of that security might have already been alienated or encumbered by the borrower. Therefore, in its own commercial wisdom, the lender had decided to go ahead with a process of adjudication and crystallization through arbitration rather than going for direct security enforcement through SARFAESI. And therefore, you could not challenge the maintainability of the arbitration proceedings basis the statutory mechanism of SARFAESI, because that adjudication under DRT is not available through SARFAESI, and you can only do that through the arbitrator under the arbitration mechanism prescribed under the loan agreement. That is what the judgment said pertaining to the challenge of maintainability.
All right. I think that explains where SARFAESI and RDB are different and which forum you would approach. But from what I heard from you, it seems that financial institution and what are financial institutions, what institutions fall under the scope of financial institutions, that and, what is debt, what is the scope of debt. Both of these terms play a very important role in what the court said, right? So could you help us understand what are the practical implications of these definitions being key to the court's holding?
Definitely, Shruti. So the idea over here is to understand that what would be a possible implication of this judgment beyond the factual matrix that the court actually dealt with. And if we try and understand what is the widest scope and amplitude of the definition of financial institution and debt, what all falls within its scope, where all can this particular judgment reach out to? We understand that financial institution under the RDB Act also covers within its ambit debenture trustees. And the concept of debt under the RDB Act also covers within its scope debt securities. And debt securities are all those securities which are listed as per SEBI, including listed debentures. So essentially, we are discussing a scenario where a listed Indian debt security, like a listed NCD, in respect of which a debenture trustee has been appointed, that kind of an amount payable under such an instrument could fall within the scope of debt under the RDB Act. Now, what the practical implication of this might be is that any amount payable in respect of a listed NCD where the subscriber has appointed a debenture trustee to take actions on its behalf might fall within the scope of the RDB Act and therefore preclude from its ambit the ability of the debenture trustee to initiate arbitration proceedings, in spite of arbitration being the preferred dispute resolution mechanism under the subscription agreement. And we already know that for listed Indian debt securities or listed NCDs, we can have domestic subscribers. We can also have foreign subscribers like FPIs who are registered in India. Therefore, whether it is a foreign investor or a domestic investor in respect of listed NCDs, a debenture trustee appointed by such subscribers might not be able to initiate arbitration proceedings for adjudication and crystallization of the amounts due by the issuer, even if there is a default by the issuer on the redemption amount. And the only option available for such a debenture trustee might be to approach the Debt Recovery Tribunal under the RDB Act, get a recovery certificate, and then move on with the recovery officer. Now, essentially what that brings us to is about the transaction documents that we are drafting in respect of such investments by either registered FPIs or by domestic investors. We have in our experience come across documentation where arbitration clauses have been included in such investment agreements. And therefore, keeping this judgment in mind, unless there is a contradictory view taken by a larger bench or by the Supreme Court, it would be preferable to avoid such arbitration clauses in such subscription agreements, lest we face a situation where there is a challenge on maintainability and you spend a long time trying to first strategize your litigation and thereafter be directed towards a different forum.
So, Arjun, this was a very helpful, explanation and a very good insight into what are the practical implications of this judgment. But one thing that comes to my mind is oftentimes while drafting arbitration clauses, as dispute lawyers keep advising that you need to look out for the seat, what terms are used in terms of clarity, etc. Right? But one peculiarity that this judgment brings out is, aside from all of these things, we consider subject matter arbitrability, whether a subject matter itself is arbitrable or not, and whether, therefore, if the agreement is about that, should you add an arbitration clause. But this goes not only to subject matter arbitrability, but one step beyond that, in terms of whether the party entering into an agreement itself is allowed to choose arbitration. And this is quite a peculiar situation, because if you are, for example, a financial institution, then under the RDB Act, you cannot choose arbitration. Now, debenture trustees are financial institutions, so if a debenture trustee is a party to the agreement, arbitration cannot be chosen. However, if there is an investment without a debenture trustee, then arbitration can be chosen. So, the entity or the party entering into the agreement is also something, another factor that we should be considering. I think with that, we can continue our discussion today. Thank you so much.
Thank you, Shruti.